Добрый день, уважаемые коллеги.
Good morning, colleagues. I'm Ekaterina Salogina-Srakova, Director General of International and Comparative Studies, which is a leading body in international law research and comparative law. I'd like to welcome you at our session dealing with small and medium enterprises and simplified insolvency regime. And UNCTRAL is one of the organizers I'd like to thank, because thanks to those people who were involved, we can have this event. Since there are more and more bankruptcies thanks to COVID-19, this topic is more and more relevant. Though there are temporary measures to support small and medium enterprises, certainly we'll be using all those for supporting the mechanisms, that is limitation and termination of audits, delayed tax period, settlement of bankruptcy rulings, etc. The fifth working group of UNCTRAL has provided expert support to the Russian delegation all the time, and the guidelines developed by the group for the bankruptcy regimes for individual and family enterprises is a well-balanced document, because it deals with certain issues of creditors' interest, principles of bankruptcy procedures, and providing support to debtors in financial distress. Also, the text of the guidelines is well formulated based on the decision of the fifth working group, which was submitted to the UN Commission dealing with problems of international trade in summer. And thanks for your attention. So we start our expert discussion. I give the floor to the moderator, Mr. Estrella Faria. Okay, you can start.
Thank you very much, Madam. And good evening, ladies and gentlemen, and welcome to the panel on MSE, Debtors and Creditors in Trouble. I am José Estrella Faria from the UNCTRAL Secretariat. It's my pleasure to moderate this panel. We know that UNCTRAL has developed standards for the development of insolvency regimes since the late 90s. They include 3 model laws and a comprehensive legislative guide to promote the modernization of insolvency laws. These instruments are also essentially reflected in the principles for effective insolvency creditor rights, the ICR principles developed by the World Bank Group. Now, these standards are originally focused on larger corporations because of their systemic impact on the stability of international financial markets. But the assessment done by the World Bank have shown that many laws do not adequately deal with the needs of insolvent micro, small, and medium enterprises, even though they are vital for economic growth. Formal MSME employ more than 1/3 of the world's total labor force and represent about 52% of private sector value added on a global scale. The pandemic, as Madam Director was mentioning, will severely affect MSMEs, which makes this topic even more relevant. It is a privilege for me to moderate such a high-level panel today, and I'd like to thank the panel organizers and the International Comparative Law Research Center for giving me this honor. We have here with us, and they will speak in this order, Antonio Menezes, who is a senior financial sector specialist with the Insolvency and Debt Resolution team at the World Bank Group, and she's also co-chair of the World Bank Group ICR Task Force. We have Irit Mevorak, who is a professor of international commercial law at the University of Nottingham and expert advisor to the UK delegation to UNCTRAL Working Group on Insolvency Law. Jason Kilburn, professor of law at the University of Illinois at Chicago, an international consultant and author of numerous publications on the comparative law of consumer and small business insolvency. And last but not least, Oleg Zaitsev, the founder and chairman of the National Association of Specialists in Bankruptcy and Distressed Assets, director of the Bankruptcy Law Division at the Russian School of Private Law in the Private Law Research Center under the president of the Russian Federation. Now, without further ado, I give the floor to Antonia. Antonia, please.
Thanks very much, Angelo. I have been asked to provide a brief overview of the key challenges that micro, small, and medium-sized enterprises, or MSMEs, face in using insolvency systems, and describe why the World Bank Group is encouraging countries to develop insolvency regimes that have been carefully designed for the insolvency of micro and small businesses. You can see these new principles in our standard setting instrument, the Principles for Effective Insolvency and Creditor-Debtor Regimes, which is available on our website and complements UNCITRAL's work in this area. Generally, what we can say is that most jurisdictions treat micro, small, and medium-sized enterprise insolvencies the same as large corporate entities, or conversely, as natural persons and sole proprietorships. These enterprises are expected to use the same commercial insolvency regime. However, these businesses have unique attributes, which we believe require specific treatment. So the first question is, what are MSMEs? Why do we care about them? One of the challenges is that MSMEs comprise a wide-ranging spectrum of businesses. The vast bulk of these businesses fall into the micro category, which usually includes sole proprietorship, single employee businesses, and small businesses, compared to medium-sized enterprises, which can have hundreds of employees. There's no uniform definition, and their size can vary not only from country to country, but also sector to sector. And countries also use different criteria in their definition, such as number of employees or turnovers. Generally, however, these businesses have less capital, a lower market share in their respective markets, a smaller workforce, and fewer resources compared to larger enterprises. However, they're estimated to contribute to roughly 60% of private sector employment, with roughly 1/3 of the world's labor force. They also fail in large numbers. One study analyzing bankruptcies in the United States found that 80% of US firms that filed for bankruptcy had assets under $1 million, and 88% had fewer than 20 employees. So what are some of the obstacles that these businesses face? First of all, the lack of incentives in accessing the insolvency procedure. Typically, insolvency processes are relatively complex, especially in developing economies where institutional support is generally lacking. And this acts as a disincentive for them to enter the system. Some of the disincentivizing features in insolvency systems include the automatic separation of management from the ordinary administration of the business upon filing for insolvency, the very copious documentation and evidentiary requirements needed to start the process. So for instance, there's often a legal requirement to file audited balance sheets for several periods, and the uncertain costs related to the period. Even though several corporate insolvency regimes contemplate sticks when directors fail to access the insolvency procedure in a timely way. For instance, the directors have a duty to file for insolvency, or there's a regime based on wrongful trading, still small businesses may be reluctant to file. And this can have problematic activities such as hiding or disposing of assets. The second problem or challenge in accessing the system and using the insolvency system is something that the World Bank has very much focused on, which is the lack of a discharge for natural person entrepreneurs. And this is a result of cultural issues, of social barriers and reputational stigma, which overall discourages MSMEs from resorting to formal insolvency proceedings. Insolvency generally seems to have a negative reputation perceived by the market to be avoided at all costs. And so often countries do not have a discharge. Natural person entrepreneurs cannot have a fresh start, and the debt follows them in perpetuity and their families. And in some countries, they still go to prison or have other very wide-ranging social consequences. And so the World Bank principles highlight the need for debt forgiveness, which is linked to entrepreneurship generally, as well as non-judicial assistance in changing the culture around insolvency and the importance of pre-insolvency tools. Thirdly, a major problem is creditor passivity. In many MSME insolvencies, particularly where the debtor is a micro business and has very few assets, large creditors remain passive and disengaged since their expected returns from the process are not high enough to justify participating in insolvency proceedings. And creditor passivity makes it very difficult to save businesses. The World Bank's stance is that any solution to MSE insolvency will need to find a balance to address creditor passivity. But also, we think it is essential that creditors' rights are not diluted. There's already a lot of suspicion in many of the countries where we work that insolvency regimes are overly protective of debtors and debtor-friendly. And our concern is that if you do not have a balance in the framework, then this could ultimately affect access to credit. So this was a challenge that in designing our principles, we really tried to ensure that there were core protections for the debtor while still retaining creditors' rights. A fourth major challenge for MSMEs is accessing finance during the insolvency proceeding. Most traditional insolvency systems make it difficult for MSMEs to access post-filing or post-commencement financing. In many insolvency systems, there is not the possibility of a super priority for fresh funding or provisions that encourage access to finance for companies going through a reorganization process. And this is very problematic, not just for small businesses, but all businesses, because distressed businesses need to access financing. A fifth challenge is the overlap between the business and the person with micro and small businesses. For MSMEs, typically, the roles of owners, directors, employees, and debt providers may significantly overlap, or a company might not be clearly a separate legal entity. And in common law jurisdictions, unincorporated businesses typically go through the same insolvency regime as consumers. This means that there's often no established ownership of commercial assets between controllers and the MSME, or entrepreneurs and their family might work for the MSME without the documentation or formal remuneration, or an entrepreneur's personal assets may be commingled with the business assets. And this can have several practical effects. First of all, creditors seek to hold the entrepreneur personally liable for an MSME insolvency through personal guarantees or security over personal assets. And something we've seen in a lot of countries is that there is no modern personal bankruptcy law. So it is very difficult for entrepreneurs to obtain a discharge, as I mentioned earlier. And the sixth and final challenge I wanted to mention is that there is often insufficient assets to fund the insolvency proceeding. MSMEs typically wait too long to file an insolvency petition. And when they do, they have insufficient funds to cover the basic administrative costs of the proceeding. And so many MSME insolvency filings are no asset cases. Up to now, we've seen two general approaches to no asset cases. First of all, if the debtor's assets are insufficient to cover the costs at the time of filing, some insolvency laws allow the court to deny the petition or order a termination of proceedings. So the debtor is not declared bankrupt and can potentially remain a zombie company on the market. Secondly, which is perhaps a preferred approach, is that some insolvency systems also provide specific mechanisms to cover necessary funds, either by requiring creditors to provide them or by creating a designated private or public fund. And this is really a huge policy concern and something that should be considered when developing specialized frameworks. So I hope this gives you an overview of why MSMEs are so important to economic growth and why they have specific challenges in using the insolvency regime that needs to be addressed. Thank you.
Thank you very much, Antonia, and also thank you for sticking so strictly to the time. I appreciate that. Let me just immediately follow up with a question to you, because something that was alluded to at the very beginning, and that is the impact of the pandemic on MSME insolvency. Could you tell us something about what measures are being introduced, both regulatory and legislative measures to address that?
Yes, absolutely. So micro, small, and medium-sized businesses have been particularly hit by the pandemic, especially in sensitive sectors such as retail and tourism. And there's a significant concern that we will still see a huge uptick in insolvency numbers. The IMF published a study recently, for instance, in 2020, looking at 17 countries, and they estimated that the jobs at risk resulting from SME business failures represented 3.1% of total private sector employment. What we've seen is that countries, as they're moving through emergency measures to longer term reform of insolvency regimes, are now focusing on SME specific regimes. So for instance, Australia, Singapore, and Myanmar have all very recently developed insolvency regimes with specific provisions for corporate SMEs. And we expect that this is a trend that will continue in the near future.
Thank you very much, Antonia. This was a brilliant introduction into the subject, highlighting the legal obstacles of standard business insolvency for MSMEs. I would now like to ask Irit, our next speaker, to address the key features of a simplified insolvency regime. Irit, please.
Thank you, Jose, also for the kind introduction earlier, and to the conference organizers for inviting me and for devoting time in your conference to this hugely important matter. It is becoming quite clear that in terms of insolvency laws and more broadly in terms of systems supporting businesses in distress, the focus should primarily be on the small entities. The small businesses, as Antonia explained very clearly, are the backbone of economies, and they are also the most vulnerable and the least resilient, especially in times of crisis like the one we are experiencing now because of the COVID pandemic. At the same time, the insolvency of the smaller entities tends to be neglected by systems because the larger cases are more visible, more reported. They create the precedents and the experience. And so in turn, they influence policy and legislation. And so I have argued with my colleagues, co-authors, that policymakers and legislators should make an effort to think about the small entities more. And rather than do small fixes or adjustments to existing insolvency procedures, which have been designed more for the large enterprises, think of the small entities first, design laws that are tailored for MSCs, for the micro and small entities. And not only that, small entities have been quite neglected in terms of the focus of insolvency laws and systems, they have also been traditionally treated counterproductively. As Antonia also mentioned, in many systems, the bankruptcy of individual business persons have been perceived as failure, deserving personal penalties and restrictions. And even when a discharge, a final release from the debts is available, it is often a lengthy process where the debtor is still liable to the creditors for quite some time after the liquidation of the business. So the new thinking, which is driven by and reflected in the new principles developed by the World Bank, which Antonia mentioned, and the related best practice recommendations that are being developed by UNCITRAL, the new approach, which is increasingly influencing countries' policies regarding MSCs in insolvency, is to provide simplified procedures for such entities which address the specific issues that they face, including their lack of resources, their lack of sophistication, but at the same time, the interest of the entrepreneurs in the business and their attachment to the business. Also the fact that the MSE creditors may be less engaged in the process, creditor passivity, as Antonia mentioned, and the need to release the individuals running the business from their debts so that they can have what we call a fresh start and contribute again to the economy. So an MSE insolvency regime should be simple, but simplicity shouldn't mean that the law needs to be minimal or thin, too focused on one aspect. The challenge is to keep the regime simple, but to ensure that it is comprehensive and well balanced. And in line with Antonia's speech, I will also focus on 6 points. These will be 6 key features of effective regimes for MSEs, highlighting this need to ensure that the regime is simple, but also balanced and holistic, comprehensive. The first feature is the all-inclusiveness of the regime. All MSEs should benefit from an MSE regime from the simplified procedures, no matter how they are structured. So the regime should apply and cover both individual entrepreneurs operating as sole traders or in partnerships and legal entities, small companies. Second, the regime should be comprehensive and balanced in terms of the procedures that it provides for these MSEs. It should include simple, cost-effective procedures for both viable and non-viable MSEs, those that can recover and those that cannot. There is currently much focus on reorganizations and on restructuring, preventive measures, pre-insolvency procedures, on avoiding insolvency. For example, in the European Union, the recent EU directive of 2019 focuses on restructuring, on preventive measures. But it is important not to be just focused on restructuring and reorganization. Reorganization of MSEs is hugely important and should be facilitated, but many struggling MSEs will not be viable and should benefit from simplified liquidation, winding up, that would also result in a swift discharge. So the regime should provide streamlined, simplified, expedited procedures with reduced formalities for both types of proceedings, liquidation, reorganization, to minimize their complexity, length, and associated costs. The third feature I want to highlight is simplicity in terms of access to the procedures. Both debtors and creditors should be able to access and commence of any of the procedures. Debtors in particular should easily initiate reorganization proceedings at an early stage, because viability may diminish if we don't act quickly. And one important way to facilitate access is by allowing MSC's debtors to start the simplified insolvency procedures without the need to be in actual insolvency or to prove that they are insolvent. But this easiness of access should be balanced or complemented by measures to prevent abuse or improper use of the procedures by debtors or by creditors, by including mechanisms in the regime such as cost recovery, conditions on discharge, or conversion of reorganization proceedings to liquidation, if it is in the best interest of creditors, and also vice versa, converting a simplified liquidation to a simplified reorganization. A fourth important feature is the concept of debtor in possession or debtor in control or entrepreneur in control. In particular, in the simplified reorganization procedure, MSE debtors should have a central role to play because usually they have the greatest interest in the success of the insolvency process and in the revival of the business. The entrepreneurs are dependent on the business. They are the business. Without them, typically, there is no business. So the entrepreneur should remain in control as a default rule. But again, this feature should be balanced with the need to ensure integrity of the process and protect creditors' interests. And so it should be required that debtors must cooperate and have due regard to the interests of creditors. Creditors as well should have the right to object to simplified proceedings or to reorganization plans. And the debtor may also need support in handling the reorganization if they remain in control, or in relevant circumstances, they may need a more intrusive supervision or even a complete displacement, allowing the authority to take full control over the process. The fifth feature concerns participation of stakeholders in the proceedings, mainly creditors. Creditors are the parties mostly affected by the MSE insolvency process, apart from the debtor itself. So they should have the right to object, consent, or propose their own solutions during the process. And they should be able to do so based on complete and reliable information about the MSE business. At the same time, such information or resources to reproduce such information, create such information about the debtor may be very limited, unavailable or very limited. Also, in any event, creditors may rationally prefer to not engage in the process because their debt may be relatively small, insignificant, which means that in terms of the design of the regime, requirements concerning provision of information are important, but the information to be provided should be concise, and it may be provided on the basis of simple standard forms. The regime should also include mechanisms to facilitate the approval of solutions, of reorganization plans, and allow creditors to be quite passive without losing their rights to be heard and to intervene. So the regime may not require the formation of creditors' committees or the need for meetings to vote on proposed plans. Agreements to reorganization plans could be based on deemed approval, whereby creditors do not need to actively vote on plans, but rather, in the absence of sufficient opposition, a plan may be regarded as approved. Namely, instead of actively vote, creditors would need to notify their opposition if they are against the proposed plan. Finally, a sixth important feature in the design of the MSE insolvency regime is the choice and functions of the institutions involved in the process overseeing the proceedings, the simplified proceedings. The insolvency regime for MSE insolvency should designate a competent authority to oversee the procedures, and that authority ideally would be the one which could be the most accessible and helpful, also in the sense that it can promote confidence and trust in the regime, and the one which is the least costly. So it may not necessarily be the court. Courts are typically burdened, and participating in court proceedings and hearings may be expensive. If it is the court that is being chosen for the task, then its functions may need to be redesigned to fit the very small cases to ensure that the court plays an assisting role and that its involvement doesn't prolong the process. Alternatively, it could be that an administrative authority could oversee the process more cost effectively and ensure that due process is observed, and that authority, including through delegation of its functions to an independent person, such as a trustee, may also assist MSEs to prepare reorganization plans or liquidation solutions, or else it may supervise the debtor or even replace them completely if necessary. Thank you.
Thank you very much, Irit, and also for keeping within the time. Actually, the last point you mentioned, in a way, ties into something you mentioned earlier on, and perhaps you may wish to elaborate on that a little bit. And that is, apart from the insolvency regime as such, could you illustrate a bit more the role of the pre-insolvency duties of debtors and on debtors, and what are the incentives to address the situation early, for instance, by informal restructurings, counseling, assistance to debtors, training, awareness, or any of such measures?
Thank you, Jose. Definitely. So that is really a very important question, because within the time that I had, I only focused on the procedures per se and the authority overseeing those procedures. But for the regime to be effective, it needs to be assisted by other aspects of the law and of the system beyond the insolvency procedures and the authority overseeing those procedures. And indeed in terms of the law, one important complementary feature would be provisions concerning the obligations of MSE debtors at times approaching insolvency before the commencement of the proceedings, to incentivize and to guide struggling entrepreneurs to consider the interests of creditors at that time, to pay attention to the financial situation early, and to consider the procedures and the assistance that can be that they can use at that time in order to address their financial situation. And Antonia also touched upon it a little bit when she mentioned wrongful trading type of proceedings. She mentioned that they are not always effective, and indeed we need to simplify those as well so that they are tailored for the MSE case. And then beyond the law, the MSE insolvency procedures to work effectively require further supporting mechanisms, some of which you have mentioned yourself. So training courses, awareness campaigns, counseling services for small debtors, early warning mechanisms, and also means to channel information about the business from relevant bodies into the insolvency process.
Thank you very much, Irit. Now I would turn to Jason. Antonia already, and both Antonia and Irit have already touched upon the issue of, Antonia mentioned being in debt in perpetuity, and Irit mentioned Irit used the word forgiveness, which I find particularly poetic in this context. But the question for you is, how simplifying insolvency regimes interacts with consumer insolvency, but in particular, what for you is the role of discharge in MSME insolvency? Jason, please.
Здравствуйте, и спасибо огромное за приглашение.
Hello, and thank you very much for inviting me today. I love talking about this topic, MSME insolvency proceedings and how it interacts with the consumers. We were really forewarned to talk slowly so that the interpretation is correct. But no matter how hard I try, I cannot talk very slowly in my native language. That's why I would like to talk in Russian. I do apologize for my broken Russian, but fortunately for me and you, my key message is rather simple. The most important thing and the best practice in MSME insolvency proceedings is it's not simplified negotiating proceedings or restructuring plans, but rather simple discharge rules in order to alleviate or to remove the liability of MSEs when it comes to their debts. And I would like to tell you that the majority of all businesses in the world are MSEs. The majority of MSEs are not legal entities, but rather individuals. Therefore, doesn't matter whether we have formal incorporation or not, individuals are usually liable when it comes to the debts of MSEs. Therefore, the key to successful insolvency proceedings for MSE are the provisions that take the burden of individual entrepreneurs. They free individual entrepreneurs and give them the right to learn from their mistakes and to revive their businesses in the future. But the majority of reforms on insolvency of MSMEs are not focused on individual support. The reforms, contrary to these facts, focus on simplifying negotiations, and the simplification of talks will not help rescuing or saving the companies and saving the people behind the companies.
Small and micro enterprises lack value and therefore have no leverages to influence their creditors in the negotiations. What's lacking is the volume of value. They have little to lose in their small businesses, and it's not worth it for them to invest in the negotiations. Large companies, to the contrary, can destroy the investments of the creditors if the creditors abandon their plans and let the businesses go bankrupt. If you owe 100,000 to your bank, as they say, you have a problem. But if you owe 100 million and you cannot pay, then it's the bank who's got a problem. But all MMSEs are in the first category. It's their problem that they cannot pay their debts. The creditors do not have to worry. Sometimes they're not even interested in the destiny of those companies and their owners. There's nothing for them to lose for the creditors in such cases, let alone encourage them to offer concessions to save those entrepreneurs. Small entrepreneurs cannot afford it to hire expensive consultants and restore their businesses. For small and medium-sized enterprises with less debts and less value, the business debtors have little to offer in exchange of alleviation of their financial burden without the threat of the courts making their rulings. They have little to lose. Therefore, as we have already heard today, the modern recommendation of the World Bank and UNCITRAL, based on best practices and existing legislation on the insolvency of MMSEs, insolvent small entrepreneurs just have to have open access to the redemption of debts without negotiations in order to contribute to either realistic negotiations or the possibility to move forward starting from a blank sheet of paper. I have analyzed the debts of MMSEs in the Arab world, in Singapore, and in Russia, and I have found that the center of these reforms requires special attention, not to the commercial aspect, to the discharge of individual debtors from their debt burden. And like Antonia said, it sometimes is lacking or doesn't work well. For instance, the draft reform in Saudi Arabia promised, through poorly informed Western advisors, promised a redemption of debts, but it did not work out. The Islamic law, Shariat, forbids them, in view of most Muslim experts. Just one Arab country, Bahrain, accepted the position that allows the redemption of obligations. However, the religious obligation requires payment of debt in full. In all other Arab countries, new laws only contribute to coordinated negotiations on restructuring plans. For the above reasons, these reforms, except in Bahrain, did not provide and will not provide the expected effect for most small enterprises and, most importantly, for their entrepreneurs. In Singapore, they have a better approach, even though in public comments the key reform is rarely mentioned. Recently, as Gretas told us, They often announce new simplified negotiation procedures for the restructuring of debt for SMEs, but those procedures would not have an effect in the absence of a negotiation leverage and effective method to free those individual entrepreneurs from the debts of their small businesses. However, starting from 2016, such a mechanism does exist in Singapore. After another reform, the bankruptcy of individuals in Singapore is now being completed by the so-called differentiated redemption of debts. That is, after the debtor completes a 5-year period of providing excess revenues to the creditor over what's needed to pay for household costs, the rest of the debt is redeemed according to law. This is a widespread approach in the world, especially in Europe. In my country, in the United States, starting from February of last year, there's a new restructuring process for debts of small businesses, works in a more or less similar way. The debtor can offer a plan for negotiations with the creditor if they want so, but they're not obligated to do so, and it's rarely successful. Most importantly, even if the creditors refuse to complete the plan, they have to retain their business and receive a debt redemption only if they give all their excess revenues to the creditors during 5 years. The court and the financial managers ensure that these payments are in line with the law. Same in Russia. There is an impressive procedure which has turned 5 years recently. It's very successful precisely because of the redemption of debt immediately, several months later. Individual entrepreneurs have access to this procedure, which correctly brings together the bankruptcy of individuals and the bankruptcy of small businesses. The debtors have the opportunity to submit a restructuring plan, as in the United States, but again, not many do so. And those who do so are usually announced, declared by court insolvent, and return immediately to the bankruptcy process, which fortunately ends up with a discharge of obligations both for the business and the consumers, exactly in line with best practices. I celebrate Russia with this success and wish even more success. Therefore, one can conclude that the correlation of bankruptcy for small businesses on the one side and for the consumers on the other hand is that both provide mandatory redemption of debt of a business or an individual, even without negotiations with the creditors, and even contrary to their desire, to guarantee for every debtor and most importantly for the society a new start. Thank you.
Thank you very much, Jason, for your comments and stimulating thoughts. As I mentioned before in my opening the floor to you, we heard about new opportunities, a fresh start, forgiveness, but the world sometimes is not forgiving. So, and the question is, how do we make sure as a policymaker and a legislator that the system will not be abused and people will not be abusing of discharge to the detriment of creditors?
Это очень важный вопрос.
That is a very important question. Fraud and other types of abuse on the part of the debtors happen much less than it is assumed or suspected. Of course, that happens, but we cannot allow that several one-off cases impeded millions of honest people in small businesses. Unstable, globally interconnected economies mean lots of financial problems, especially in the context of COVID-19. Therefore, we can be sure that most of the wave of financial trouble is not due to abuse on the part of debtors, but other objective suspensions. The creditors have ways to identify hidden assets if they exist, and if those and unless those creditors do that in the course of the insolvency proceedings, the usual system of claiming debt would not identify those assets either. So we're not losing anything here. The best we can do is create effective institutes, as Irit has said, effective institute of financial administrators, trustees, courts, to identify violations and to punish for those violations. We should not ignore those problems. However, we should not victimize this benefit because we cannot guarantee its perfect implementation. Thank you again.
Thank you very much, Jason, for your very clear reply. Your comments also pointed out to the anomaly that it is that fraud represents, and also to what creditors can do, for instance, to identify hidden assets. The creditors can do also something else to try to escape and evade the consequence of insolvency, and that is to try just to reach out to the assets of the personal guarantors of the debtor, and that's exactly the question that Diego would be addressing now. And мы продолжаем по-русски.
And we continue in Russian. Thank you very much. It is a great honor for me to speak to this audience amongst people whose textbooks I use to teach my students. I would like to say that Professor Kubern, your Russian is superb and many, many times better than my English, but I will still speak in Russian. I would like to also thank Professor Kubern for a positive assessment of our bankruptcy law. I'm glad that we succeeded in something, and I would like to say that starting September of last year, we had an out-of-court bankruptcy procedure admitted, and I'm glad to hear this passionate presentation by Professor Kubern that individual entrepreneurs must have the same simplified access to a discharge of debt as the consumers, and I agree completely. The matter of fact is that we have this problem of whether this out-of-court simplified procedure of individual bankruptcy introduced September last year, whether it can be used for individual interpreters. I believe that yes, but the tax authorities resist. They are convincing for the legislators, but today I have a new argument and will try to persuade the Russian state even more passionately to use this procedure for individual entrepreneurs. Thank you for the topic that I was offered to raise today, personal guarantees. This is very, very relevant today in Russia. It's it's very seldom that when financing is provided by banks, that banks don't ask for any trustees from the debtors, say a wife or other family members. That happens almost very rare, and a business that goes bankrupt turns out that it has to pay debts, both the businessman, his wife, sometimes even children or elderly parents, which leads to extremely difficult situation for these people. And as experience has shown, even the entrepreneurs themselves do not completely understand where a business can lead them, and those, I mean, their family don't understand it at all. I remember very well, somebody asked me, can I sign a contract, a trustee contract, but one that I should not pay anything? That's to get a loan in the bank. And I'm glad that in the draft recommendations prepared, there's a section on personal guarantees in situations of SME bankruptcies. And I recommend all the Russian-speaking listeners who have not seen it to read the text of these recommendations, because Russian still remains a working language at UNCITRAL, which makes it easier for Russian speakers to read UNCITRAL documentation. Not all international organizations operate like that. So what I wanted to note now is the procedural consolidation. There's a lot of attention paid to it in the draft recommendations, because procedural consolidation is something that is easier to adopt. The Russian law already is familiar with elements of consolidation for individuals, and after a lot of hesitation, judicial practice finally decided to bring together the bankruptcy of a wife and a husband. And if it's a family, then this part of the recommendations can be easily implemented in the Russian Federation, because indeed, if, for example, the guarantee is given not by a wife, but by another family member who does not have common property, it would be very convenient to make it in such a way that the bankruptcy proceeding for the businessman, his children, his brother or parents, that they be coordinated. And I think that it should not be too difficult for Russian courts. And I hope that the UNCITRAL recommendations will help here, because procedural consolidation is not just a situation predetermined of material consolidation as it is understood in Russia. If a husband and a wife have everything in common, then they're co-owners of everything. And it would be obvious then bankruptcy procedure must be consolidated. This, the same should apply to other cases where we can see as a minimum the need for procedural consolidation of such cases. I think this will not be very difficult. And of course, what's more difficult, and you can see that the recommendations are more careful about this. Bankruptcy law is always more careful, is the material sensitive, but I'm happy to see that the recommendations are careful in making a step in this direction, and they carefully suggest thinking about the fact that the bankruptcy of a corporate business or an individual business of a businessman to alleviate the size of payments that he himself must make or his family members must make as guarantors. In particular, it's suggested to now, in the situation of business bankruptcy, for the payments to be affordable for the debtor and his family members, considering their income. This issue very recently, in the end of last year, was discussed again when the Russian Supreme Court prepared new explanations regarding these guarantees, and the issue arose again about how courts are supposed to protect the guarantees provided by family members to the business owner for amounts obviously unaffordable for these people.
But I regret to say that I could not persuade my colleagues, in particular as far as foreign jurisdictions are concerned, and as far as surety agreements are concerned. Our court, our judiciary was very tough in this, because lack of funds to pay for sureties gives no chance to challenge it. So if UNCTRAL adopts new guidelines, then perhaps we could go back on the discussion here in Russia, providing chances to mitigate the approach in such situations when people have to pay billions and billions while their assets are much smaller and revenues are smaller. And from the very beginning, the bank realized that. And he knew that these amounts are not at all realistic in the case. So thanks for your work of what we are doing on Central, and I hope that you will succeed in what you're doing. Thanks.
Thank you very much, Oleg, for your comments, and thank you also very much for your thanks to Uncentral. And I take your invitation to ask you a question as a follow-up that also is very close to our heart, because we're looking to this issue, and that is the relationship you see between discharge and MSME insolvency and MSME access to credit. And I'm not only talking about access to credit during the insolvency proceeding, which Antonia has mentioned, but more generally in an economy. Thank you.
Thanks for the question, because this question seems to be eternal in a way, and it's not clear how it affects the procedures and what regime on recovering the debt on the debt discharge will be formulated, and how it affects the bank or other creditors to provide funds, and what terms and conditions. And that is why certainly when we discuss the material consolidation and decreasing or delay for paying out based on personal guarantees, certainly we provide a kind of protection, but this may raise obstacles for getting funding. But sometimes it's just vice versa. While the entrepreneur understands that in bankruptcy system, he would be able to discharge debts, to write them off, and his relatives will know that the surety conditions may be mitigated, then it may become an incentive to take credits, because there should be incentives for both parties. So we should not tell people that if you go bankrupt, then your relatives will have to pay for your debts all their lives. No, I think that you should not be scared by limitations of the access to credit. And I think that it's important for the bankers and creditors as well as businesses.
Thank you very much. We are running out of time. I have to close this panel. We'd have had a lot to discuss, I think, but I'd just like to stress one takeaway that I take from this panel, and as there is also great need for training and the application of a special regime for MSMEs insolvency, because we cannot benefit on an army of experts to advise either the court or the special institution that is running this MSMEs insolvency on whether it is a prospect, there is a prospect for rescuing that business, or that we should be sent straight to litigation, so to liquidation. So there is a lot that need of training that will be out there, as there is also for banks in doing proper risk assessment also when they're extending credit to MSMEs, rather than perpetuating this business of banks grabbing all assets they can put their fingers at, even at the price of disregarding the liability limitation that the law provides for the business. But this is a more of a philosophical question that perhaps would be for yet another future UNCITRAL project. I think all those who have participated in this panel will join me. Thank you, the speakers, for their brilliant presentation. I think everybody has learned a lot. I haven't quite had enough time to learn how to perfection my English to Jason's level of excellence. I think that's going to take another 20 years. But from a point of view of substance, we all learn a lot from Antonio, from Irit, from Aliek, and from Jason. Thank you all very much, and thank you all the participants for their attendance. Thank you.
Thank you.
Bye.
Thank you.